to interview their clients?
Yes, I have, Your Honor.
I have.
Okay, wonderful.
And I wanted to request a breakout room for position 4, Taylor Franklin.
Okay.
Thank
Any
you.
other breakout requests?
No breakout request, Your Honor, but one of my clients, Miss Hickson, is not on the calendar. She was at felony first appearance, but she's not on our calendar.
Okay.
Jewel.
Did they set, so I'm assuming that bonds were not set on her misdemeanor offenses?
Correct.
Okay. Not sure what will happen there.
Hmm.
All right, it's 2:00, so we'll go ahead and get started. Are the members of the state present? Oh, yes, I see you. Okay, everyone's here. Wonderful. This is the state expedited accusations calendar in the state court of Fulton County, Georgia. I am Judge Melanie Williams, and today is November the 14th of 2023. All defendants, you have an absolute right to remain silent. Anything you say can and will be used against you. You also have the, please mute if you're not speaking. You also have the right to an attorney. This particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this particular proceeding. Miss Bridgewater, what is my reset date?
Yes, Your Honor. It's going to be on the other side of Thanksgiving, November the 28th.
Okay, so those who receive a surety or cash bond will be reset to November 28th, state all-purpose calendar. Those who receive a signature bond, whether through the jail or pretrial, will be reset further notice. Does anyone have insight? I'm sorry, Ms. Abden, what was the name? It was Hickman or Hickson?
Oh, that's a good afternoon, Your Honor. That'll be an NOD.
Okay, wonderful. Thank you.
Thank you.
So, Ms. Abden, that answers your question. Let's
Thank you.
begin. Who do we have first?
Good afternoon, the ACDC. Position number 6.
All right.
I'm sorry, Your Honor, wrong calendar. Position number 2, Ms. Carter Anderson.
All right, thank you. Good afternoon, Ms. Carter Anderson. Your case is 23 CR 007039C. In this case, you're charged with theft of service and simple assault. Do you understand your rights? Oh, where is Ms. Carter Anderson? Is that you, ma'am? Please come forward. Do you understand your rights? It's muted. Can we unmute at ACDC? All right, ma'am, I just need you to nod. Are you Miss Carter Anderson?
Yes, ma'am.
All right, and you understand your rights.
What were my
All
rights?
right. I'm sorry?
I said, what were my rights?
Oh, you have a right to remain silent. Anything you say can and will be used against you, and you have a right to an attorney. Additionally, I'm broadcasting this over the internet. It's also being recorded. Do you understand that?
I do. Can I ask a question?
No, don't ask any questions.
All
You're
right, that's good.
representing.
That's what I'm gonna
Okay, hold one
understand.
second. Hold 1 second, all right? Can I have her history, please, Miss, is it Miss Roberts?
Yes.
All right, Miss Roberts, can I have the history, please?
6 cycles, last arrest September 12th of this year for theft by shoplifting. That is an open case with the city of Atlanta. Appears to have one other open case from the city of Atlanta for blocking public way and begging or soliciting. And one conviction, 2006, disorderly conduct. If released on pretrial, level 2 would be the recommendation, and nothing further.
Okay. Mr. Walker, is this your case?
Yes, it is, Your Honor. In this case, law enforcement was dispatched to Fido's Irish Pub located at 922 Peachtree Street, where they spoke to the manager, Miss Jenny Goodwin. She advised that the defendant essentially dined and dashed with a bill totaling $88. As the defendant was walking out of the location, the manager tried to prevent her, to try to get her to pay for the food items. The defendant did refuse and ultimately pushed Miss Goodwin out of the way, calling her out of her name. Police were called, and now we're here. So the state will be asking for a signature bond through pretrial services. stay away from that instant location. No contact with the victim, who is the manager at the location, Ms. Jenny Goodwin. No weapons, drugs, or alcohol while out on bond.
All right, is Ms. Goodwin present and wishes to make a statement? All right, Ms. Abdon, in light of the information before me, I'm inclined to give this defendant an SOB through the jail with the stay away and no contact. Do you have anything you'd like to add to the record or any objections?
No objections. My client does deny the allegations. I just wanted to state that for the record. And I do believe she has a hold on her booking sheet. And I did not hear anything from pretrial. So if pretrial could just tell us if she does have a hold, I would appreciate that.
I heard the open case. Do we know if she has any holds, Ms. Roberts?
Give me one moment to look it up.
Thank
All
you.
right. In the meantime, she's going to receive a $3,000 SOB through the jail. That's going to be $1,000 on the theft of service and $2,000 on the simple assault. She's to have no contact with the alleged victim, stay away from that Irish pub, and have no alcohol, drugs, or weapons as a condition. Is there anything additional other than the hold information, Mr. Walker?
That is all. Thank you, Your Honor.
Your Honor.
There does appear to be a hold. It says Atlanta, so I'm not sure. It's a failure to appear hold.
Oh.
Okay. All right. I know you have some
you.
questions, Ms. Carter Anderson. You should probably speak to your attorney. Do you have a question about the bond?
Oh, wow.
What is your question? Can we unmute her quickly? But please advise you have a right to remain silent. Please don't say anything to incriminate yourself.
Yeah.
Wh-
And
what
Ms.
is-
Carter Anderson, you got a signature bond through the jail. What that means is that you don't have to pay any money to get out. And you just have to return to court for your next court date. If you don't, then that $3,000 will be the penalty. So that's what that means.
Thank you, Rachel. I appreciate it.
You're welcome.
All right. That concludes your case. All right. Best of luck to you. Who do we have next?
We have position number 1. Mr. Bowles.
Okay. All right, Mr. Bowens, your case is 23 CR 00706 4H. You're charged with fleeing and attempting to elude while driving with the offense date of November the 6th. You understand your rights?
Yes. Yes.
All right, Ms. Roberts gonna have the history, particularly the driving history, if you have it.
I do not have his driving history. I can look it up for you if you would like me to.
Well, let's go with what you have for now.
Criminal history is only 4 cycles. Last arrest 2013 for probation violation. Underlying charge was a marijuana possession from 2012. Level 2 if released on pretrial. If you would like me to, I can run his driving history. If the state
I
doesn't
think
have it.
it's all right. I think that's gonna be okay. All right, Mr. Walker.
Yes, 1 second, Your Honor. Okay, so in this case, the defendant was pulled over for having expired tags and no insurance. Upon making contact with the defendant, he advised that he had his insurance information at home. While the officer was attempting to write the citations for the said infractions, the defendant pulled off, and essentially that is the basis for the fleeing. The state is asking for a signature bond through the jail, no driving without valid insurance or tags, no weapons, drugs, or alcohol while out on bond.
All right, I'm inclined to grant that. Ms. Abdon, anything additional?
Just for the record, Your Honor, my client did advise me that this was a misunderstanding and the officers were supposed to be following him home. They instead called him and told him he had a warrant and he had turned himself in on Monday since Friday was Veterans Day, but no objections. And he does now have a valid insurance and registration.
Okay. Defendant is going to receive a $2,500 signature bond through the jail. He's not to drive unless he has valid insurance and tags for any vehicle. He additionally is to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing from defense. Thank you, Your Honor.
All right. Best of luck to you, Mr. Bowens. Who do we have next?
Position number 11, Ms. Ward.
All right, good afternoon, Ms. Ward. Your case is 23 CR 00706 9G. You're charged with having drugs not in the original container reckless driving, and DUI. You understand your rights? All right. Can I have the history, Ms. Roberts?
5 cycles. Last arrest was July 7th of this year for a DUI. It was on the booking screen in Odyssey, but I didn't see a case for it. I'm not sure what happened with that case. Only one conviction from 98 for driving while license suspended or revoked. Level 1 and released on pretrial.
Okay. All right. And as a reminder, level 1 is once a month. Okay, thank you. All
Yes, Your
right.
Honor.
Oh, please pronounce your last name for me.
Yes, good afternoon, Your Honor. Georgia Casadakis.
Okay, I hope I get that right, Ms. Cassaday. Please proceed.
Thank you, Your Honor. Let's see, officers were dispatched to 111 Millview Avenue. For count 1, the officer found that the defendant possessed various prescription drugs and they were not in their original container. Count 2, reckless. The defendant was driving a GMC Sierra and she ran into Miss Courtney Manning's retaining wall and walked away. And for count 3, the DUI, the officer observed, well, actually, she was under the influence because she was taking several drugs that rendered her less safe to drive. She was staggering. She had to balance herself in the police car and she appeared confused. The state's concern is that there's a risk of reoffending. The state's recommendation will be a signature bond through the jail for the charge 1, the original container, a signature bond through the jail for the reckless, and a $1,500 surety bond for the DUI. As far as the conditions, no further contact with the victim, Courtney Manning, that's Manning. Stay away from 111 Millview Avenue. Drug and alcohol evaluation, no drugs, alcohol, or weapons while out on bond. And at this time, Your Honor, I would like to sound for the victim, Courtney Manning.
All right, Ms. Manning, if you are present or wish to make a statement, this is your opportunity. Hearing and seeing none. Ms. Atay?
Yes, Your Honor. My client is a 48-year-old mother of 1. She denies the allegations and states, as for the hit and run, that she lives in the neighborhood and was stated that she whoever was there, that she told them, I'm going to come right back because she needed to get dressed because she was just out in her pajamas, I guess. And she has been steadily employed for 5 years as a server at a restaurant, and we're requesting a signature bond through the jail.
All right, thank you. Defendant's going to receive a $3,000 split bond. It'll be 1,000 signature through the jail for count 1, 1,000 signature through the jail for count 2, and 1,000 surety for the DUI for a total of 3,000 split. She's not to drive unless she has a valid license or permit issued by the Georgia DDS. She additionally needs to have no drugs, alcohol, or weapons as a condition, have no contact with Miss Manning, and stay away from that incident location. Is there anything additional?
Excuse me, Your Honor, but what position was this?
11.
I didn't show a hit and run.
Reckless driving.
Okay, I thought I heard someone say something about hit and run.
Maybe I said that. If I did, I'm sorry. It should be, so drugs not in the container is 1,000 SOB, the reckless driving 1,000 SOB, and the DUI is 1,000 surety. And I think I said hit and run because she hit, well, is alleged to have struck.
Okay, okay. I know I heard a hit and run. Okay, was SOB through the jail?
Yes, SOB through the jail.
Okay, great. Thank you.
All right, best of luck to you, Ms. Ward. That concludes your case. Who do we have next?
Position number 4, Ms. Taylor Franklin.
All right, good afternoon, Ms. Franklin. Your case is 23 CR 007066Y. In this case, this is a breakout requested case.
Yes.
Okay, so we'll have to go to breakout. This calendar isn't long, so we can do it now. All right, do you understand your rights? Is that a yes? All right, let's have the history before we go into the breakout room, please.
First arrest.
First
Judge,
arrest.
I'm sorry, I don't mean to interrupt. Can we do the breakout towards the end of the calendar?
Well, this calendar isn't that long and I tend to move pretty quickly. So let's can we go into the breakout now, please? And this is the only breakout requested.
Okay, Judge.
Thank you.
And we need Miss the iPhone Andrea well, that's her mother. I don't know if that's.
I don't know if you want the victim slash mother to come in or.
Let us talk first and see
Okay.
why. Let's leave the mother out for now.
Okay.
Miss Abdom, would you have wanted to go on the breakout?
Yes, please.
And how about Miss Georgia? Can't pronounce your last name.
Yes, Your Honor. Kastakis, but Georgia's fine too.
All right, after hearing from the attorneys and the witness in this particular case, defendant is going to receive a $3,000 signature bond through pretrial services level 1. She's to have no further violent contact with the alleged victim and have no alcohol, drugs, or weapons. She must remain compliant with any prescribed regimes as a prescription as part of her pretrial SOB. Is there anything additional through the state or the defense?
Nothing from the state.
No,
All
Your
right. All right. Best of luck to you, Ms. Franklin. That concludes your case. Who do we have next?
Physician 10, Thomas.
All right. Good afternoon, Mr. Thomas. Your case is 23 CR 0070663J. You're charged with simple battery. Do you understand your rights?
Your Honor.
All right. Can I have the history, Ms. Roberts?
And Your
Sorry.
Honor, this is, sorry, this is a conflict. We weren't able to get a conflict attorney in time. Just wanted to let the court know.
Thank you. So, Mr. Thomas, what that means is the public defender's office cannot represent you today. So what I'm going to do is listen closely to your history. If I do not feel that I can give you a signature bond at this time, I'm going to reset you to tomorrow's calendar in the hopes that a conflict attorney will appear to represent you. All right. Can I have the history, Ms. Roberts? No. Don't say anything. Go ahead, Ms. Roberts.
Recycles, last arrest June of 2022 out of Florida for battery. I couldn't tell if that was a conviction or not. If released through pretrial, the recommendation is level 2.
Okay, thank you. Ms. Dunlap, please proceed.
Thanks, Your Honor. So officers responded to a victim, Ms. Sharna Lockhart, stating the defendant attacked her while exiting the train. She was standing near the exit door when the train arrived at, it looks like, 5 Point Station. The defendant touched her. She advised him not to touch her. Once he did again, he pushed her off the train. She ended up swinging her back at the defendant to try to create distance between them. They continued to push each other. And it looks like from the video, Ms. Lockhart sprayed the defendant with some unknown substance. She ended up running down the stairs to try to catch another train and get away from the defendant. He had started to follow her, but decided to turn around and walk away. It doesn't look like Ms. Lockhart is on, but she did previously say that she saw him in the neighborhood she used to live in. They had gotten into an argument before where the police were involved. And then when she saw him on this day, she didn't think anything of it. He just randomly attacked her. The state is looking for a signature bond through pretrial, a stay away from 5 Point Station, family violence intervention program, no further contact with the victim, Sharna Lockhart, and then no drugs, alcohol, or weapons while on bond. I'm sorry.
All
The FIVP shouldn't have been up there. This is not family violence.
Okay. I'm sounding for Ms. Lockhart at this time to see if she wishes to make a statement. Okay. Defendant is going to receive a $1,500 surety bond at this time, and he will be reset to tomorrow's SCA calendar in the event that he doesn't make it, in the hopes that a conflict attorney will be present. He is to have no contact with Ms. Lockhart and additionally have no alcohol, drugs, or weapons as a condition.
Your
Anything
Honor,
further, Ms. Dunlap?
yes, sorry. Can we just add anger management course?
We cannot, because I gave him a surety bond. All right. Best of luck to you, Mr. Thomas. That concludes your case for now. We will see you back tomorrow in the event. I know you have some questions or concerns. I do not want you to say something on the record that will hurt your case. What is your question? You don't have a question. All right. Well, I'm resetting you to tomorrow.
I have one question. I'm sorry. I'm not completely I don't know what a surety bond means. So could you explain it to me, please?
You're gonna have to go through a bonding company and post a bond. I'm resetting you to tomorrow so that an attorney can assist you, okay?
I can't get out today.
You can if you pay the bond, yes.
Okay.
All right, best of luck to you. Who do we have next?
Physician 9.
All right, pronounce your name for me
Active
and your last name, say it for me.
Bo.
Mr. Bo, your case is 23 CR 0070662Y. You're charged with battery family violence. You understand your rights?
Yes.
All right. Can I have the history, Ms. Roberts?
Yes, 3 cycles. Last arrest was February of this year for a battery family violence. Give me one moment. I did not write down whether or not that was a conviction.
It was dismissed.
Thank you. Level 1 if released on pretrial.
All right, Ms. Dunlap.
Thank you, Your Honor. So this incident stems from June 11th. The defendant woke the victim and Miss Tiara Thomas out of her sleep, calling her the B word and to get out of their apartment located at 3150 Roswell Road. Looks like the building name is Hanover. As she tried to leave, the defendant began hitting her in the head and face. He caused a laceration to her eye, bruising to her face, a bump on the back of her head. When she went in the lobby to call the police, the defendant came downstairs and punched her again in the face in front of the concierge. The state is looking for a $6,000 surety bond. The recent case of the battery family violence was from February 16th. It was dismissed only last month, but he was supposed to have no contact with this victim and to stay away from that address. It wasn't dismissed until last month, October, by Judge Mincy. So we're looking for the $6,000 surety bond and no further contact with the victim, Tiara Thomas, 12 weeks anger management, and then a stay away from 3150 Roswell Road. The victim did indicate they're no longer in a relationship. They don't live together. It's unclear who lives where at this point. And then no guns, drugs, or alcohol on bond.
All right. I'm sounding for Ms. Thomas. If you're present and wish to make a statement. Ms. Atai, please proceed.
Yes, Your Honor. My client denies the allegations. He states that he didn't see Miss Thomas in June. He states that this is all stemming from the February incident. He has graduated from college. He is self-employed. He doesn't qualify for public defender services after this. He's a level 1. We're requesting a signature bond through the jail with no further conditions. He lives alone at the 3150 Roswell Road address.
Okay, so Ms. Thomas is alleged to not live there.
Yes.
Is that the information you have, Ms. Dunlop?
It just says that they don't live together. It didn't state who lived there now.
Okay. All right. Defendant is going to receive a $3,000 surety bond. He's to have no contact whatsoever with Ms. Thomas. If he resides at that location, and Ms. Atai, you said that his name is on that lease?
Yes.
And the victim does not reside there?
Yes.
To be clear, what we'll do is we'll have him return one time with law enforcement to make the determination that Ms. Thomas does not live there. If Ms. Thomas is not there, he can return to that location. If she is still living there, he can collect his items and must stay away. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything additional?
She doesn't live there, Your Honor. The victim advocate spoke to her.
Okay, so we will remove the stay away part. All right. Take care. That concludes your case, sir. What do we have next?
Position 8, Giles.
Good afternoon, Mr. Giles. Your case is 23 CR 007061J. And you're charged with DUI, following too closely, obstruction, and erratic lane change with the offense date of November the 13th. You understand your rights?
Yes, ma'am.
All right. Can I have the history, Ms. Roberts?
3 cycles. Last arrest was April of 22 for DUI out of Gwinnett County. The disposition just says bind over and nothing further to add. Level 1 if released on pretrial.
All right. Ms. Dunlap, please proceed.
Thank you, Your Honor. So officers, this incident stems from November 11th. Officers observed the defendant's black Dodge Challenger. He turned right, it looks like on Medlock Bridge Road, and then started to accelerate at a high speed. The officers saw him commit multiple failures to maintain violations. He crossed the fog line several times. He was following too closely to a sedan in front of him. When officers pulled him over, he had bloodshot, red and watery eyes. They asked him where he was coming from. He stated that he was at home, he was going to work. They also asked him how much alcohol he consumed, and he stated not enough. They asked him to participate in several sobriety tests. He first complied, then refused. He then began to make several derogatory and racial comments towards officers. They first took him to Alpharetta Jail, but his disruptive behavior, they ended up refusing him there. They tried to take him to Fulton County Jail, but because of his behavior again, Fulton County refused him. He was then admitted to Grady, where he was medically cleared and then transported back to Fulton County, where he continued to use a bunch of racial slurs toward the officers. The state is looking for a $10,000 surety bond, no further driving while impaired, and no drugs, alcohol, or weapons while on bond.
All right, Ms. Hampton?
Thank you, Your Honor. My client is 35 years old. He's been living in Georgia since he was 12 years old. He lives with his aunt here in Georgia. He also has family here in Georgia, so he has strong ties to the community. He graduated from high school, attended some college at Georgia Perimeter. He's gainfully employed. He works as a machine operator, and he's been doing that for the past 7 years. He has a son who is 7 years old. He does work 12-hour shifts typically, and he does spend every other weekend with his son and any chance he gets. So he does have a familial and financial obligation to his child, and I am asking that Your Honor take that into consideration when setting bond today. My client does deny the allegations as stated in the warrant. He stated that this was a misunderstanding, and he does deny being under the influence. Setting a bond for him today would be like setting no bond at all. He doesn't have the means to pay. If Your Honor is not inclined to grant him a signature bond, then I am requesting a reduced bond, as the $10,000 bond would definitely ensure that he remains in jail for the next 2 weeks.
All right. The defendant's going to receive a split bond as follows. It'll be 2,000 surety on the DUI, 1,000 SOB through the jail for the following too closely, 500 surety for the obstruction, and 1,000 signature through the bond for the erratic signature bond through the jail for the erratic lane change. He's not to drive without a valid license issued by the Georgia DDS. Additionally, he's to have no drugs, alcohol, or weapons as a condition of that split bond. Because he did receive some surety bonds, as a reminder, he will be reset to state all purpose on the 28th. Is there anything additional?
Nothing else from defense. Thank you, Your Honor.
All right. Best of luck to you, Mr. Giles. Who do we have next?
Position 6, Hartnett.
All right, Mr. Hartnett, your case is 23 CR 00706 You're charged with simple assault, family violence, cruelty to children, and battery family violence. Do you understand your rights?
Yes.
All right, can I have the history, Ms. Roberts?
First arrest, if released or pre-trial, he'll need a co-signer, and level 1 is the recommendation. Nothing.
Okay. All right,
Yes.
Mr. Walker?
Yes, Your Honor. In this case, law enforcement was dispatched to 567 Roswell Road, where they spoke to the victim. I believe that's the defendant's mother, Miss Jessica Hartnett. She advised that her and her son were over or in some type of disagreement about him being punished. At that time, he did become physical and attack his mother. He also threatened her and other family members in the home. I believe his stepfather, whose name is Randy Ward. The state is asking for a signature bond through pretrial services. No further violent contact with Miss Jessica Hartnett, Mr. Randy Ward. I believe our victim advocate has spoken to his mother. She is amenable to him returning to the home if he agrees to attend Next Level Boys Academy. And additionally, the state is asking for an 8 p.m. curfew. And of course, I was out for the victim, his mother, Miss Jessica Hartnett.
Okay.
And if I didn't say no weapons, drugs, or alcohol while on bond, of course, no weapons, drugs, or alcohol.
Okay. Hold 1 second. All right, Ms. Hartnett, I will hear from you. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right, I am not sentencing your son today. What I'm most concerned with are any concerns you have for your safety and your desire for contact with the defendant. What would you like to tell me in light of those instructions?
I just believe that Dessa made a series of poor choices. I did call the police to hold him accountable. Neither myself nor my husband are in fear of being around him. We're not opposed to him being in the home. We have spoken before he turned himself in to go to the Boys Academy, as a means to get him some type of assistance and support. He is in high school. He's a senior in high school. So we want to see him graduate, want to see him doing well. And, I don't have any issues with him. This was an isolated incident. He's never done anything of this nature before. And with the steps that we will take, I'm not concerned that it will happen again in the future.
All right. I appreciate you coming to court and making that statement. Mr. Ty, anything you'd like to add to the record?
Yes, I'll just state that my client is a 17-year-old high school senior, as his mother stated. They do want to see him graduate and be successful. Of course, she stated that she would like, the curfew and the conditions, and we're fine with that, and a signature bond through the jail.
All right. I'm going to send his signature bond through pretrial. Ms. Hartnett cannot be his co-signer. Is the stepfather was named as an alleged victim as well, Mr. Walker?
I will have to check the accusation.
I think so, because
Yes, Randy Ward.
So he can't co-sign either. Ms. Hartnett, do you have someone else that can serve as co-signer for your son? Neither you or your husband will be able to do so.
Yes, someone can.
We need the name of that person so that we can put it onto the order so that they'll be able to come get him out of the jail.
Okay, Asia McDowell, and that's my sister. His aunt.
Can you spell the name for us?
First name is Asia. Last name is Mcdowell.
Okay. All right, so defendant is going to receive a $3,000 signature bond through pretrial, $1,000 each count. He is going to take the 1-day anger awareness course and have no further violent contact with the alleged victim. He is going to stay engaged and enrolled in high school as a condition, and additionally, he'll have an 8 p.m. curfew. And of course, no alcohol, drugs, or weapons. Is there anything additional from the state or the defense?
Nothing from the state.
All right. Ms. Roberts, do you have all the information you need?
Yes.
I believe his mother has a question, Your Honor.
I know. I'm going to send her to Mr. Ty so we can keep moving. If you have a question, can you message Mr. Ty, please, Ms. Hartnett? Or you can message her in the chat, okay?
Yes.
And Ms. Roberts, if you wouldn't mind messaging his mother an address where he can be picked up, that's usually, I think,
And
what's
not to
happening.
belabor the point, I know the victim had requested that the son is enrolled into Next Level Boys Academy. I'm not
I'm
sure.
not gonna require that. I just said high school because I
Okay.
don't know what the admissions are. I can't require that Next Level Boys Academy take him. So we'll leave that word.
Understood.
All right. Who do we have next? Best of luck to you, Mr. Harden. You've getting a second chance. Please comply with all the conditions and be respectful of your mother. Best of luck to you. Who do we have next?
Position 3, Curtis.
And Mr. Ty, if you wouldn't mind helping the mother. Thank you. I appreciate that. Mr. Curtis, your case is 23 CR 0070658. In this case, you're charged with simple battery against a police officer. Do you understand your rights?
Yes, ma'am.
All right. Can I have the history, Ms. Roberts?
Yes, 17 cycles, 6 out of Las Vegas, 2 out of Louisiana, 6 out of Arkansas, 3 out of Georgia. Last arrest was from the 15th of May from this year for battery. Case number 23 CR 002969C. That's an open case. I am showing 4 FTAs from Arkansas, 2019, 2021, 22, and 23, and nothing further.
All right.
Level
Mr.
2 is
Walker.
a trial. Sorry.
Mr.
In
Walker.
this case, it's my understanding that the defendant was being transported to the jail on separate allegations, if you will. And during that process, he spat on the arresting officer. The state is asking for a $1,000 surety bond and no further contact or no further violent contact with Officer Colton, no drugs, weapons, or alcohol while out on bond. And the reason why I'm asking for the surety bond is because the defendant has a history of FTAs.
Okay. Ms. Abden?
Thank you, Your Honor. These allegations, this charge was part of two other charges that were on the calendar yesterday. He did receive a 1,500 signature bond through the jail on those two. And I guess we just, forgot to deal with this one. They're all from the same circumstances. But
What were those charges, Ms. Abden or Mr. Walker? The ones that are associated with this?
I would have to look it up, but to be clear, that's a separate case, and he was being transferred to the jail. But I have to look up his charges from yesterday.
Okay. All right, Ms. Abden, continue.
Thank you. So he is 37. He was born in Georgia, grew up here in Georgia, and he moved away for some time before returning recently. He's been living here consistently in Georgia for the past 9 to 10 months. He recently lost his job, Your Honor, as of 3 to 4 days ago. He was working at Little Caesars Pizza. He has no income at this time, so his indigency is a concern. He was also living at the incident location of the other case. I think it was public drunk and yeah. And it was at a I think it was called the Six. I will look it up, but it's an extended stay motel. As part of the case yesterday, he has a stay away provision. So he needs to find somewhere else to stay. I've connected him with a social worker who will come see him to assist him with that. He does deny the allegations as stated in the warrant, Your Honor. And he would have no ability to pay whatsoever. I understand the state's concern regarding the FTA. He did have unstable housing at the time. I did discuss that with him. And he will be represented moving forward by our office and does understand his obligation to return to court. And as a social worker, will be assisting him possibly with housing if he does need, then, he will have a stable address and will be returning to court. So given the fact he's already been in jail for 3 days, I am requesting a signature bond, and that signature bond be through the jail.
All right, defendant will receive an $8,000 signature bond through the jail. He's to have no further violent contact with that alleged victim in this case and have no alcohol, drugs, or weapons as a condition. Is there anything additional?
Nothing else. Thank you, Your Honor.
All right, best of luck to you. Who do we have next?
Oh, excuse me, Your Honor. For Desmond Hardnett, the mother did want to state for the 8 p.m. curfew, if you could amend that to allow him to go to work, because sometimes she said that his work keeps him out until 10 p.m.
He can go to work, school, functions, and otherwise the curfew does apply. All right.
Other than work. Thank you.
All right. All right. Who do we have next?
Position 5, Goodman.
All right, Mr. Goodman, your case is 23 CR 007067J. You're charged with obstruction. Do you understand your rights?
Yes, ma'am.
All right. Can I have the history, Ms. Roberts?
I show 17 cycles. Last arrest was June 8th of this year for a probation violation. Appears to be on probation for possession of marijuana less than an ounce. That's from June of this year, 12 months probation. Also appears to be on probation for criminal damage, battery, theft by taking, aggravated assault, obstructing or hindering, to make an emergency telephone call, and 2 counts of criminal trespass. That's out of Henry County from January of this year, 6 years probation. 4 driving while license suspended convictions, 23, 17, 14, and 2005. DUI convictions, 2006, 2017. 4 FTAs, 2017, 2018, 2022, 2023. Level 4, if released out on pretrial, and nothing further.
All right, thank you, Mr. Walker.
Yes, Sean. In this case, law enforcement was dispatched to a car collision on Trinity Ave. The defendant was one of the parties involved in that car collision. And speak on the defendant, he was not compliant, would not cooperate with the investigation, if you will. He was loud, unruly, and was causing a scene, if you will. The officer advised him if he did not calm down, he would be placed into custody. The defendant continued to be irate at that time. He was taken into custody. The state is asking for a signature bond through the jail. No weapons, drugs, or alcohol while out on bond.
I'm inclined to grant that, Ms. Abden. Any objections or things you'd like to add?
No objections, just that he's denying the allegations as stated in the warrant.
All right. Defendant will receive a $5,000 SOB to the jail with the conditions that he have no alcohol, drugs, or weapons. That concludes your case, Mr. Goodman. Best of luck to you. Who do we have next? I believe the last case is position 7. Is there an announcement?
I'm checking, Judge. Position 7 is going to be a Grady reset. Yeah.
Okay. We have completed the entire calendar, I believe. Then, Ms. Bridgewater, will you review it for me?
Well, I will say I think position 7, our recommendation was going to be a signature bond. I don't know that.
But if we didn't waive their appearance, Mr. Walker.
I just want to make the court aware.
I know.
Thank you.
This Miss Abden, do you have any? I'm sure you didn't discuss a waiver with your client.
I didn't speak with him at all, Your Honor. I was told he may be at Grady. Hopefully, maybe I can speak with him tomorrow.
Okay, and if you are able to speak to him, or Mr. Howard is, please ask if he'll waive his appearance so that he can get out if the presiding judge determines that those facts support it.
Absolutely.
All right.
Yeah.
Ms. Bridgewater, if you'll
Yes,
review it.
ma'am. Okay, once again, the reset date for the SAP calendar is going to be November 28th. Position number 1 is being reset further notice with a $2,500 SOB through the jail. 2 is reset further notice with a total $3,000 SOB through the jail. Position number 3 is being reset further notice with a $5,000, I'm sorry, a $8,000 SOB through the jail. 4 is reset further notice with a $3,000 SOB through pretrial. 5 is being reset further notice with a $5,000 SOB through the jail. 6 is reset further notice with a total $3,000 SOB through pretrial. Position number 7 is being reset till tomorrow. It is a medical reset. 8 is going to the SAP calendar with a total of $4,500 split bond. 9 is going to the SAP calendar with a $3,000 good bond. 10 is being reset till tomorrow. However, there is a $1,500 good bond. And 11 is reset to the SAP calendar with a total $3,000 split bond. Are there any questions, comments, or otherwise?
I have a question for Mr. Walker.
Mm-hmm.
Do you know what happened to Tatum?
Yeah.
That person was referred to PAD, and it was accepted into their program, so the case remains unaccused, and they should be released on a consent bond.
Okay, we're on pretrial and we're surrendering that bond. I don't know how that would affect with PAD.
Oh, they have another
Unless
case.
the judge tells me otherwise, not to surrender it.
Do we know what the other case is?
Shall we loop me in? What's happening? I was just getting ready to go.
So this person was
Wait, hold on one
referred to
second.
PAD.
I think let's let courtroom 2 go. I don't
Okay.
think courtroom 2 needs to stay with us any longer. Thank you all for your patience and for indulging me regarding that breakout. You all take care. Bye-bye. Take care. Have a good afternoon. Okay. So let's figure this out. I'm sorry. There was a party who was referred to PAD, but now they have an additional case.
Right. So if pretrial comes off the additional case, they won't be released to PAD, obviously, because there'll be a hold.
And then and that may affect PAD's acceptance, or does that?
Yeah, you can't be in jail
Yeah.
or have an active case with PAD.
That's what I thought. So that person can't go to PAD.
Well,
Well, it depends.
You can tell me not to surrender the bond if you
Okay,
want.
well can we tell me what it is? What's the new case?
I'm trying to look. What would be the old case that we would have to?
Oh, that's true. That's the old one.
I don't.
The open case. Let's call it the accused.
Accused case. You're correct.
The open case is possession of tools for commission of a crime, identity theft, fraud, and laundering a problem. 23 CP 223-275.
Well, that's a felony case, so we have no jurisdiction with that.
Nothing I can do. There's nothing I can do, right? It would have to go through a magistrate judge.
Yeah, correct. Well, we can still sign our consent bond, and if he's released.
That has nothing, right? There's nothing that any of us on this Zoom conference can do. So, Ms. Roberts,
sorry.
Yeah, I'm sorry, you were muted.
So the other case is a felony case, correct?
Correct.
Yeah. So there's nothing I can do?
pretrial is going to surrender that bond.
A judge
Yes,
would have
that's
to
our,
tell,
sorry.
a judge would have to tell her not to, and I can't because it's a felony fine. So
Okay. Well,
if
go ahead.
I was gonna say if he's taken to felony first appearance, there, I guess he's not
All
going to
that
felony
happens
first appearance.
simultaneously, like will the bond be surrendered today and a hold be placed on him in the felony matter? Like that quickly?
Right, that's a good question. Ms. Roberts, do you know? I think Ms. Roberts froze as well, or she's very deep in thought trying to figure this out. Ms. Roberts, you still with us? Okay. Well, I think the reality is there's nothing any of us can do unless Ms. Abden has a dynamic solution. But as far as I know, I can't sign or unsign any felony related bond.
That is my understanding as well. I did send the consent bond for this one. So
We'll just do that, and the rest is out of our hands at this time.
And if and when he is released to PAD and we confirm it, we will dismiss this case. So good luck to Mr. Tatum.
Oh, my computer did freeze. I heard the question though. The order will be submitted today. It just depends on how fast records process it through. So it may be done today, it may not be done today.
Okay.
But yeah.
Well, let's get ours through today.
Okay, correct. Sounds good.
Okay.
All right. Any other outstanding matters from anyone?
Nope.
If not, take care. I'll see you all at tomorrow's FCA calendar.
See you
Take care,
tomorrow.
everyone. All right. Bye-bye.
Thank you,
See
Anna.
everybody. Bye-bye.
Bye-bye.